And a large part of what we're thinking about is the crime of aggression that occurred, the full-scale invasion of Ukraine on February 24th, 2022, and the gap that we have in the international legal system that prevents the ICC, which has made, of course, charges for war crimes committed in Ukraine by Russians up to Vladimir Putin, has issued arrest warrants, but hasn't been able to deal with what Robert Jackson of the United States at Nuremberg called the crime of crimes, the crime that enables all the rest, that the judges said was encompassed within it the evil of the whole. And the whole question of how, we can deal with Russian impunity, as one of the speakers was describing it, the young woman from Pussy Riot, never accountability, not for the crimes of Stalin, not for Katyn Forest, not for the KGB, not for the purge trials, not for the crimes in Eastern Europe, not for certainly the crimes of the Holodomor in Ukraine, now the invasions. And we see impunity breeding impunity. And we see it also in Syria, as we had our good friend Omar al-Shogri, who went through the torture chambers of 215, and then the city of death, Sidnaya, and managed to survive. How is it that this international legal system can respond to that? That's the question. And I'll let each speaker speak to how they're contributing to that. Our first speaker has been, it's our third panel today together, my former colleague at the Sierra Leone court, former president of our court, international human rights lawyer, Geoffrey Robertson KC. Geoffrey?
Let me tell you an answer to the question that was posed by the previous panel. What do you do about Putin? Well, they spoke about combining in foreign countries, keeping members of their population abreast of what's happening in collecting of evidence. And last night we saw that wonderful film it was very moving, about collecting evidence for a prosecution. But there's not going to be a prosecution, is there? Because maybe in 20 years' time, Putin will stumble into a dock like some old Nazi. But he's not going to be given up. Indeed, he's got a new lease of life with President Trump. And the prospect of, because Russia is not a member of the ICC, we do have a law of aggression, which was finalized as late as 2010. It fits Putin like a glove, but he's not going to be prosecuted. He's got nuclear weapons, so that's an end of that. But I wrote this little book, The Trial of Vladimir Putin, not as a matter of wishful thinking, but because I think there is a way to get him by trial in absentia. Now, British lawyers and American lawyers hate trials in absentia. For some reason, they like dressing up in court and having a defendant to cross-examine. But it's a perfectly normal approach in France, in many European countries, in Ukraine itself has trials in absentia. So the great attraction of a trial, if we ensure that Putin is properly defended by good lawyers as amici, friends of the court, Alan Dershowitz would take the brief without
He'll take any brief.
I wouldn't recommend Rudy Giuliani, but this is and you've got to remember that, okay, aggression, it's easily proven. The tanks were pictured as they rolled towards Kiev. The question that's raised by Mersheimer and the Chicago school that seems to have taken Trump's fancy can be decided by experts. Russia has filed a defense. It's told the Secretary General that it's relying on self-defense. Well, that is something that I would have thought can readily be shredded. But you've got to remember that the great impact of Nuremberg, on which the ICC was a successor, is that it actually produced a judgment that confounded Holocaust deniers ever since. And the attraction of having an authoritative judgment by eminent international judges would go some way to dispelling the propaganda that the Kremlin has put forth over the last 3 years. So I think there is much to be said against the Anglo-American view that we shouldn't have ever trials in absentia, and that that is the one way forward in which an authoritative account of this dreadful act of aggression can be it can be elucidated. So that would be my contribution to this discussion of aggression, that since we can't get the aggressors, it's time to amend the ICC statute to allow trials in absentia, and indeed to be a few other changes necessary so that aggression is not just confined to those 45 countries that have signed up and they're never going to commit it, but is a freestanding crime, and a tribunal can be put together by those nations committed to justice and can hold at least trial in absentia of Vladimir Putin.
Thank you very much, Geoffrey. And we'll have other speakers talking about ideas for doing that in a special tribunal on aggression, which could be established under the auspices of the Council of Europe, and maybe have that trials in absentia. I think maybe David Crane will speak to that. We now have a speaker, Alexandra Matveychuk, as everyone knows, shared the Nobel Prize 3 years ago, has spoken eloquently across the world in favor of justice for the people of Ukraine, and we're very happy that she was able to join us today. Alexandra?
Thank you very much for providing me a floor. It's a huge honor for me to address to the distinguished audience. I'm a human rights lawyer, and I'm documenting war crimes in this war which Russia has launched against Ukraine. For the last 3 years of large-scale war, we jointly documented more than 81,000 episodes of war crimes. While this war turns people into the numbers, what we are literally doing, we are returning people their names, because people are not numbers, and life of each person matters. All this hell, which we now face in Ukraine, is a result of total impunity which Russia enjoyed for decades. Russian troops committed horrible crimes in Chechnya, in Moldova, in Georgia, in Mali, in Libya, in Syria, in other countries of the world. They have never been punished. They believe they can do whatever they want. A year ago, my friends and colleagues from Russian Human Rights Center Memorial published a report. They analyzed the Russian tactics in Chechnya, in Syria, in Ukraine, and they told, this is the same war crime playbook. The chain of wars, chain of crimes, and chain of impunity. We must break this chain. But we face with a gap of accountability, because there is no international court which can prosecute Putin and top political leadership and high military command of the Russian state for the crime of aggression. But all atrocities which we are documenting, it's result of their leadership decision to start this war. And that is why we must create a special tribunal on aggression without waiting how and when this war will end, and hold these people accountable. Two things which I found extremely important. We all know that the last decision of the core group of state is to create such special tribunal in the frame of Council of Europe. We also know the yesterday decision of United States to withdraw the investigators from atrocity crime group. And we have a doubt whether or not we can rely on United States in this joint efforts to create a special tribunal on aggression. But still, it has to be done, and two questions are still actual. First, will this special tribunal on aggression be international or hybrid court? The difference is crucial because only international court can overcome the immunity which Putin has according to international law. If not, it will be very difficult to explain people in Ukraine, people in Germany, people in other countries that we invest enormous efforts to create a special tribunal to prosecute people responsible for the crime of aggression, and this tribunal has no power to prosecute the most responsible one. But second question, it's even more important. What is the timing of this special tribunal of aggression? Will it start to see aggression from the February 2022 when the large-scale war started, or when the war started and aggression started itself from February 2014? Because we had previously the bad example of creation of special registry of damage, which provide a chance for compensations only for victims after the February 2022, and close their eyes for dozens of thousands of people affected by Russian aggression in previous 8 years of the war. Still, these two questions are unclear, and that's why I would like to focus on it in my introductory remark. And I would like to finish with something which I found very essential. When I speak with politicians, I see that they see justice but in very narrow way. They see justice like something which have impact to the past or to the future. To the past because we prosecute someone for something which had already been done. To the future because it can be a strong signal to people that if you will do something similar, you will be also prosecuted. But what politicians sometimes don't understand, that justice has a huge impact to present. What do I mean? If even part of Russians start to be doubt that probably this time they will not avoid responsibility, this doubt will be converted in chilling effect of brutality of human rights violations. And this means that just with decisive legal actions, we can save thousands and thousands of lives. Thank you.
Thank you very much, Alexandra. At this point, let me turn to my good friend Richard Goldstone, who probably needs no introduction, former prosecutor of the Rwanda and Yugoslavia tribunals, a judge of the Constitutional Court of South Africa, head of the Gaza Commission, most recently in charge of the internal oversight expert review of the ICC, who continues to work in his 9th decade, extremely energetically for the cause of accountability and justice. And over to you, Richard.
Thank you very much, Stephen. I'd like to broaden the discussion a little bit. I think the question that was put is how to prosecute the crime of aggression, not only, but obviously including the case of Russian aggression in Ukraine. The problem really is that many powerful states don't like to put themselves in a position where they even remotely might be charged with aggression. Aggression obviously is a leadership crime. It's defined in the Rome Statute as a crime only really to heads of state and heads of military, and so it's par excellence a leadership crime. The opposition of not only the United States but also the United Kingdom and France led the definition of aggression in the Kampala Amendment really to exclude the permanent fine. Because they insisted, and really there was a capitulation in a way to get a consensus. The compounder amendment to the Rome Statute only gives the ICC jurisdiction over aggression when the accused government explicitly accepts it or the Security Council confers it. And obviously in the Security Council, there's the veto of the P5, so there's no way that they're either going to explicitly agree to it or not to or not to veto it. Steps are being taken by a number of states to widen the jurisdiction over the ICC over aggression at a special meeting of the Assembly of States Parties to be held this coming July in New York, if it can take place in the proposed amendments would place the crime of aggression on the same footing as the other crimes, as the other atrocity crimes defined in the Rome Statute. The other issue I'll briefly deal with is the question of head of state immunity. The International Court of Justice in 2000 held that the so-called troika, the head of state, the president, and the minister of foreign affairs, who are in office, cannot be charged in domestic law for the crime of aggression.
International.
The International Court of Justice held that it's only an international court, such as the ad hoc tribunals and maybe the ICC, would have jurisdiction. It's clearly broader. The Sierra Leone tribunal clearly had jurisdiction over the heads of state over the troika. The problem, as I understand it, the Council of Europe has agreed to be involved in setting up a special tribunal for aggression in the Ukraine by Russia. The problem is the United States is insisting, as I understand it, that the Council of Europe tribunal should be based on a reference of domestic law from the Ukraine. Well, under Ukraine domestic law, the head of state immunity applies. And that's the idea, that the United States, I understand the UK and France are in agreement that it should only be domestic law that should be charged, and again they're protecting themselves from the question ever of being brought to court on the ground of aggression. So the only way you're going to get Putin or any other leadership responsible for aggression before an international tribunal would be if it's an international court, as considered by the International Court of Justice. So that's where we are, and unless we can overcome that inhibition, we're not going to see a court against Putin or any other aggressor.
Okay. Well, thank you very much, Richard. And I think our next speaker is David Crane, who I know has been involved in the Council of Europe thing. I saw the question to him, though I know he wants to keynote this, is maybe we look at the brighter side of the U.S. withdrawing from the whole process and let the Council of Europe do it right and include heads of state. Clearly, as Alexandra said, you've got to hold the person responsible criminally, who is the person that's responsible for the decision, or it's a meaningless process.
My compliments to members of this panel, particularly my close friends who I've been around with for, dare I say, 30 years. Yeah. Really, I want to really kind of focus on just a couple things, because our time is precious here. I concur with the commentary of my previous panelists discussing the various perspectives, but we can do this. The bottom line is it's a political decision. We are close to a political decision with the core group and the Council of Europe. Really the United States, whether it wants to play or not in this, is of no mind. Obviously, there are political ramifications, but Europe is going to have to use this initiative of creating this special tribunal for aggression as a way of showing that they can stand on their own in defending democracy. We were very close. Richard and I have been on a high-level working group advising the core group of nations. In fact, actually drafting the current statute that creates this special tribunal. So again, we have the capacity to do this. We've done this before. There's jurisprudence that supports this. But I think, and the bright red thread of modern international criminal law is politics. And so what we really want to focus on here, should we are able to move forward, and it has to happen this year, I think we will lose political momentum if we do not. The creation of this tribunal has to happen in 2025. I've just come to the conclusion, and I know that Richard has heard me say this a couple times, perhaps others, but the key to a special tribunal on aggression perhaps is not actually having Vladimir Putin in the dock, but in fact, actually just indicting him. If we can get that far and have a tribunal created and indict Vladimir Putin for his aggression against Ukraine, that's a huge political statement to the other dozen or so authoritarian governments watching like crocodiles as to how Europe stands up to this. It'll send a huge signal that heads of state who invade the sovereign territory of another country are going to be held accountable. So I think this is the point I want to make. We have the capacity to do it. We've drafted 7 steps on how to actually create this. In reality, once we get the green light, we could have this up and running within a month. We would have an indictment of President Putin and the Troika in a year or less. It's a fairly, in the overall scheme of things, for those of us who have created courts, it's a fairly inexpensive approach. It's an easy crime to prove. And with the proper plan, we could do this. But 2025 is the year we have to do this. Time and distraction are Putin's ultimate weapons. And he has played this, and it is his ultimate weapon. And the distractions are such that he could prevail just by the fact that the world is starting to come apart. So Europe has to create this special tribunal through the Council of Europe, and I applaud this. And then we need to get this started with or without the United States. And I think we can do that. But that's going to be a very good signal to the rest of the world that Europe is going to stand strong against whoever is trying to oppose or destabilize the world. So those are my comments. I have more to say, but again, thank you for the time.
Well, thank you very much, David. Our next speaker is the former Federal Minister of Justice of Bundesrepublik Deutschland. We here in Germany today are in a country that's been a leader in establishing international justice for the crimes, indeed still prosecuting people who were involved in the Nazi death camps, but of course, most prominently the involvement of Germany in universal jurisdiction cases, structural investigations of Syria, first conviction for torture out of Syria, institution that our friend Omar al-Shogri was tortured in, convicted in Koblenz, the leadership now on universal jurisdiction and structural investigations on Ukraine, and of course we've just heard from my fellow American David. The ball is in Europe's court. Sadly, the U.S. should be exercising leadership and isn't. But turning to the former Minister of Justice, what should we do?
Well, thank you so much for your wonderful introduction. You see, it's an honor to listen to that, what you are praising on the German, let's say, attitude. I hope this will stay, as you said, because as you know, there are some tendencies, let's say, to weaken the ICC. I was looking forward to this panel because I feel that every one of us feels that the rule of law should prevail to rule of power. But on the other hand, there is no time to have a detailed discussion. So I restrict myself to 3 things. There is a warrant against Mr. Putin. And that what we could do is to make sure that he cannot travel without the danger of being detained. You see, it's interesting that nobody denies the warrant against President Duterte. We know, and this is my second point, of course, we know the model is South Africa and the Constitutional Court there in the al-Bashir case. This was a real good thing, and you can be sure that in Germany, we will look how you did it if such a case should arise here. Secondly, the ICC couldn't have, let's say, issued a warrant in the crime of aggression. The first loophole, that's what you said, and I fully agree with you, I won't repeat that, but there is another birth defect, because both parts, the aggressor and the aggressed country, must be members of the court. So you see, this is a loophole we have to close, because this is, well, mostly an invitation, not only to those 5 you mentioned, but to others, smaller countries, to, well, commit an aggression, a very clear aggression, where all the other, let's say, facts of Article 8 are there. So we have quite a lot to do, I think, but I am not comfortable with a European High Court against Putin. I have to say that. I don't know whether we could use the German International Code on International Criminal Law if he came to Germany. If he doesn't, we don't have this, let's say, possibility of making a procedure against someone who is not there. But on the other hand, I feel that the legitimacy of a European court, that would be a special court in any case, would be a bit doubtable. So I think we should try to get the warrant, not because of the crime of aggression, but crime against, let's say, war crimes and crime against humanity, to become, let's say, efficient. It's an illusion, I know that, but I think it is more realistic than a European court. Thank you.
Well, thank you very much, former Minister. Next speaker, again, needs no introduction. Those of us who were at the movie last night, the film, The Crane's Call at the French Embassy, certainly saw a lot of Anya Neistat, who's been investigating crimes by Russia since the Second Chechen War, but has also been involved in accountability around the world, and not just when it comes to countries that are opposed by the United States. Famously did an investigation on the mistreatment by Australia of Afghan refugees in Nauru Island and the concentration camps there. And so a person that's really on the lines, on the front line, building cases and building now these universal jurisdiction cases out of Ukraine that are being accepted, we hope, by our friends, the federal prosecutor in Karlsruhe. So Anya, would you give us your thoughts?
Thank you very much for the kind introduction, Stephen. And a lot has been said by some of the most brilliant legal minds. So, and I'm like one of the last people standing between people and their drinks. So I will try to be very short. I would just speak up on what the minister just said, because I think we do need, I know I don't want to distract from the name of the panel, but I do think the big question is, what is of key importance, to prosecute the crime of aggression or to prosecute Putin for something? And I actually don't necessarily have an answer to that. I think both have their own importance. And I do think that we're not talking about the crime of aggression. We do have possibilities. The arrest warrant is out there. Whether or not he will be prosecuted, I want to be a little bit more optimistic. Milosevic thought he never would. Duterte thought he never would. And here we are. That's what I tell myself every time before going to bed. So please do not discourage me any further. But in theory, it is not a completely impossible scenario when, for example, he's no longer the head of state, right? That also could happen. We just had somebody on the previous panel here who has some aspirations in this regard. But I do think that on all of the other crimes, on crimes against humanity, on war crimes, there is an enormous amount of evidence already. And I do think that that should always be on the table. Second quick point I wanted to make is, and I wonder really actually what you all think about the prosecution, or at least the investigations opened into the crime of aggression by countries who do have that crime as part of their universal jurisdiction. And there are 39 countries who do have this crime, and 10 of them have actually absolute, or so-called absolute universal jurisdiction, meaning there doesn't need to be any connection of the perpetrator or the victim to the country. And none of them technically would be able to prosecute him, right, because of immunities. However, nothing prevents them from opening the investigation and then providing materials to whichever tribunal would look into that. That leads me to my next point, which has been something that deprived me of sleep for the last few months as the peace talks, as the peace negotiations in Ukraine are on the table, is evidence. And I do hope that whichever tribunal we're talking about, we are thinking about what's going to happen to all the evidence that has been collected by Ukrainian prosecutors, because the bulk of the evidence, yes, there have been multiple other investigations opened, but the bulk of the evidence is in the hands of Ukrainian prosecutors. Some of it has been handed over to the International Criminal Court, but I assure you from first-hand knowledge that by far not all of it. And I think whatever we're discussing now, whether it's a crime of aggression or other crimes for which we do want to see Russian leadership held responsible, the question of evidence should be very high on everybody's agenda. And probably the last thing I would like to mention, and it's I guess it's about thinking creatively, and I think all of you talked about it, of the, not just the symbolism, but the importance of, for example, trial in absentia that could indict Putin. But I also think that there is one other thing, and not to tap ourselves on the shoulder, but last year we also submitted a complaint to the Human Rights Committee under General Comment 36, right? And that is one way to at least have, if the committee agrees with us, to acknowledge that the crime of aggression was committed. Because if they agree with our conclusion that all killings, that's the case is based on violation of the right to life claim, right? Killings committed as the result of an act of aggression. And we intentionally filed this complaint on behalf of both civilian casualties and military personnel. Of course, the committee has never dealt with this because we actually haven't had an obvious act of aggression since General Comment 36 was adopted. But I do think that their ruling will be very, very important, including for whichever tribunal, whichever court will take it on. So I do think that these slightly symbolic steps are equally important until we have something more practical and promising in place.
Well, thank you very much, Anya, and wonderful to hear about the case in the Human Rights Committee. Remembering our friend Ben Ferenz, who made that argument often, left us now 2 years ago at the age of 103, but saw the crime of aggression as depriving even the soldiers that resist that aggression of their basic human right to life. So let's turn to our last speaker. You talk about evidence. My friend David Akerson is the expert on dealing with evidence and the indexing and analysis and all the technical tools that are available for both gathering it and analyzing it. I also should mention that he was a prosecutor in the People's Tribunal, the Court of the Citizens of the World, organized by our friend Jakob Bashiel, in which we held not a trial, but a confirmation hearing under ICC rules, which can be done in absentia at The Hague, and eventually confirmed an indictment of Vladimir Putin for the crime of aggression. 16 witnesses, including Alexander Matveachuk, appeared. David, give us your thoughts.
Yeah, and I know I'm the last person between you and your drinks, so I'll be very quick. I do want to emphasize how excited I am to hear flexibility in kind of how we go forward, including in absentia trials and maybe tweaking the statute. One of the things I've been doing recently is finalizing a report for a North Korean advocacy group. And they're very interested in the crime of aggression as it applies to aiding and abetting. And that's a very tricky thing when you look at the crime of aggression, the way it's defined in ICC. But it's going to be really conspicuous if we prosecute Russian leaders and leave out this kind of major development where just in a couple of months in last year, in September and October, North Korea delivered 10,000 containers of military supplies from its ports to Russian ports. And the amount of material that was going to Russia to save Russia, Russia was flailing. They were struggling to maintain their military operations, and North Korea came in to save the day. And Russia had to rebuild their ports to receive the amount of material that was being delivered to them. And so I think as long as we are putting statutes on the table, I think one of the things to think about is how we incorporate modes of liability, because the Kampala amendment where we added the crime of aggression had to be watered down in such a way to maximize the number of countries that would agree to it. And one of the things we did is made it harder to bring in aiders and abettors. And I'm kind of excited to hear that this is maybe a prospect that we reconsider how we defined it for a European Council court or some other kind of form of accountability. Two other points. One is that Ambassador Rapp and I did this trial a couple of years ago, 2 years ago.
2 years ago, just
and I was a prosecutor. We were prosecuting or confirming the indictment against Putin for the crime of aggression, and it was the easiest confirmation that has ever been done. But what is important about that, and I don't want to discount these symbolic trials, because really the only issue in that case was there any arguable defensive reason for Putin to invade. All the other elements were kind of self-evident. And we had these experts who came in and gave very eloquent explanations as to why that is impossible. And that's the kind of thing that, even if we do it in absentia, Council of Europe prosecution, we need to preserve the evidence, not only of the kind of evidence that Anya is collecting, but high-level expert evidence of people who are, at the end of their careers, and we never know how long it's going to take to get Putin in the dock, or hopefully Kim Jong-un. We want to preserve that evidence in a structured way. And these, whether it's People's Court or a European Council court, these are excellent ways to preserve the evidence. And one other final point, my job until it was upended by Trump when he suspended foreign aid was a very important project that I hope I hear news reports on an hourly basis whether the funding is back or whether it isn't. But what we were doing with the National Police of Ukraine, who have 13 regional offices to collect war crimes evidence, all of that evidence is going to be useful for the crime of aggression as well. And you can imagine that these police officers in Ukraine, who were normal police officers up until the Russian invasion, so they were doing things like police officers everywhere. In their local communities, they were arresting people for driving while intoxicated or robberies or burglaries. Now they're collecting war crimes evidence. And war crimes evidence needs to be centralized because or evidence of aggression has to be centralized in a system that can accommodate all of that evidence. Because one of the main things you need to discern is patterns in order to make a strong case of aggression. And you can only find all of those patterns if the evidence is collected. And the US was—
This is interesting. We should discuss this further.
The State Department was funding a major project, millions of dollars, to provide the National Police of Ukraine with the technical capability to centralize evidence, and a lot of it is video, drone video capturing live evidence of Russian crimes. I saw one instance where a drone, they were showing the Russian soldiers burning alive 2 Ukrainians in a car that was captured by a drone. And they could click between 6 different cameras on that drone to show different camera angles on that one drone. That's all over Ukraine. The amount of evidence is overwhelming, and Ukrainian police don't have the capacity to do it. So I don't know if there are any members of the European Parliament here or anybody else who is independently wealthy. Someone needs to fund the National Police of Ukraine and build their capacity, both technical and skills, to do this work, because we don't want to lose this evidence, and it's going to be lost if we don't save it. So I hope Elon Musk.
We're not counting on Elon. But thank you, David, for that very constructive idea. I heard Herta saying, yes, go for it. So I think we have a path forward.